Great. Welcome, everyone. Thank you so much for joining the ICODR member meeting. There's so many things going on. I almost feel like we could take the whole hour just talking about developments in the field, but we're not going to do that because we have our esteemed guest, Christina, with us to talk about Greencounsel, and we can learn more about her platform in a minute. But I just wanted to say to everyone, I hope everyone's doing well. It's great to see you. It feels like the pandemic is coming unstuck. The travel is beginning again. The conferences are happening in person. And I hope we get an opportunity to all have meals together and shake hands in the near future. But I just wanted to make sure that everybody's aware of Alberto's conference, the ODR Expo.tech, which is happening at the end of April. I think that's going to be amazing. And then also the Online Dispute Resolution Forum meeting, which is happening in Dublin, which I think some of us will be at in person, but there's going to be online participation opportunities. So please make a point of putting both events in your calendar because I think they're going to be great. But before we dive into Christina's presentation, does anyone have any news or developments or anything they'd like to share? Tim, I thought you shared some announcements about your collaboration with Vili. I was wondering if you could tell us a little bit about how that's going.
Sure, right. Yes, thanks, Willie. Good evening, good afternoon, or good morning, wherever your time scale may be. I'm Nuva Law, working with my company Trust Arbitration, have developed an online arbitration service for high volume, low value personal injury claims in England. And that's now live and operational. We signed with a motor insurance company called Admiral, and they're one of the market leaders, and also a number of claimant law firms. And claims are being processed, and we've moved the settlement period down from something over a year during the COVID period to our SLA, which is about 11 days on the value of claims. So that's a big change, and hopefully it's a start of things which will grow and grow, because the market is quite large and the number of people with the same problems is quite large. But it's good news for claimants and for insurers as well on their costs.
That's great. Now, are you pursuing other insurers and going to pitch similar mechanisms to them?
Sure. Yeah, we're talking to a number of insurers. We've got a couple of others who've signed up, and another few in the pipeline as well. So interest is being shown.
Fantastic, fantastic. All right. Well, I'm already envisioning a future ICODR event where we can bring you in to talk about that in more detail. But thank you for sharing. And I also wanted to point out our good friend Lucia's new podcast, which is just amazing. It's really going gangbusters. So everybody should check it out. I don't know, Lucia, if you want to put the link in the chat. And also, I've been having some conversations with ICODR friend Ian McDuff in New Zealand. He's interested in starting a podcast focused on the latest developments in ODR, maybe primarily focused on the developments in Southeast Asia. But I think he's wondering whether or not he wants to make it an ICODR podcast or just make it an ODR podcast. But I think if anybody's ever read Ian's blog posts or articles, I think he'd be a really wonderful person to do that. So Lucia, I don't know if you want to share any details about your podcast.
Well, first of all, I think and I know Ian as well, and I think that we should talk. It's a great idea.
Sure.
I think there's so much going on. I mean, I almost had to drop what I call an espresso shot edition just to break down the Amazon unionization.
Oh yeah.
Aid, right? There's so much going on all the time that we want to keep up and be on that cutting edge. And sure, I'll put a link in the chat, but I don't want to take away from today's topic.
No problem, no problem. And hi, Richard, good to see you. And Chip and Chuck, it's wonderful to have all you here. Hi, Claire. So any other announcements that we want to share before? Oh, I see Chuck's got an announcement. Yeah, the ABA Dispute Resolution Section Conference. Yeah, so I don't know, Chuck, if you want to say anything about that. It's going to be online, and we're going to have a lot of great ODR related sessions there. Claire and I are also doing an ODR track at the Association of Family Conciliation Courts conference, which is right after the ODR forum. But Chuck, do you want to say something about the dispute resolution section?
No, nothing to add, just highly recommend it. It's a really amazing collection of programs and speakers, and the price can't be beat.
Well, I was sad because I thought we were going to do it in person in LA, but then they made the game time decision to do it online. So that's okay. Hopefully this will be our last one online, and then we can all get together again next spring. Okay, with that.
Conferences,
please,
I have a question.
Yes, Katerina.
Did anybody submit a proposal to present on ODR at the ACR conference? The application deadline was yesterday.
Yeah, Claire, you put in a proposal, right?
You did? Oh, good. Great. Glad to hear that. Thanks.
Yeah. I'm really interested to see how that conference is going to be in Orlando, right? I think in the fall. So, yeah. And
hybrid, though.
Hybrid. Okay. So both in person and online. Yeah. And I would point out, Bob, thank you for joining. Good to see you here. Bob has launched through Next Level Mediation a new training on his platform. And I know we've had a couple demos of it over the past year or so with ICODR, but Bob gave me the ability to go through this training and check it out. And it's incredibly cool. I mean, I think I understood the power of the Next Level platform a little bit before I went through the training. But then once I did the training, I'm like, wow, okay, man, there's some real high power. So we just did an article on mediate.com. Maybe we can put a link up in the chat to that, sort of talking about the training and sort of the rationale behind the Next Level platform. But I do highly encourage all of you to check it out, because it really, not only did it sort of change my tune about decision science and, understanding the Next Level platform, it really changed my thoughts about where ODR may be headed over the long term. So Bob, I don't know if you want to say a word or two about that before we give the mic to Christina.
Oh, glad I joined in time. Yeah, I've developed some training so that it's a little easier to understand how the platform works, because I know decision science is not usually on the top of everybody's mind. But just keep in mind that, any kind of dispute resolution at the end of the day is essentially a decision between two or more parties that started with opposing agendas, or at least different agendas. And, so there's lots of room for applying decision methodologies, and the platform is basically geared toward enhancing kind of online dispute resolution with other tools that help people get to decisions without having to sit for hours in front of video conferencing kind of tools. So I recommend everyone go try it out. The 30-day free trial, and just sign up for the, I gave mediate.com a 50% discount on the training. It's only, it'll cost you about $50 to go through all the training and get a certificate basically in how to use the system. Then of course it's up to you. So
what you do after that. Yeah. So I did put a link to the chat with the coupon code in there. So if people have time to check it out, I highly recommend it. Okay. Any other announcements before we dive into our guest presenter today? Okay, great. Well, let's go to Christina. Christina, thank you so much for taking the time to present to us today. I've really enjoyed clicking around the Green Council website, but I'm really excited to see the tool that you've built. So why don't we hand it over to you, and you can walk us through it, and then we'll open it up for some discussion when you're done.
Okay, thank you. Thank you very much for having me today. Just a few words about the agenda for the presentation. First, I will do a short introduction about Greencounsel, its legal tech platform, and what problems we are solving, the features of the platform, and some examples of the services running on it. And thereafter, I will focus on the dispute resolution services and the thinking behind those in an online dispute resolution perspective. So these first two items will take approximately 20 minutes. And thereafter, I will do a short demo of the online arbitration platform, where you will see how we have implemented the thinking and structure that I will talk about. Let me see here. Yeah. So my name is Christina Blomkvist. I'm a Swedish commercial and dispute resolution lawyer and founder of the Swedish legal tech company Greencounsel. The company was started 5 years ago, and in addition to practicing law, I have also coded for over 30 years and in various ways also used this knowledge in my work as a lawyer. So before setting up my own company, I often used to build applications in various ways to streamline and automate my own work as a lawyer, and realizing that much can be done there to free lawyers' time to do what only a human can do, and minimize. Let me see, can we focus? Do you all see the PowerPoint, or should I perhaps share it instead?
Yeah,
I think if you right click on Christina's picture and then you select, or you click the three dots and you do pin, then it will pin her video to be big on the screen and you'll be able to see the slides. She's using this very cool technology. You can see where she sort of overlays the slides, which is cool, but it sort of becomes her background in her video. So I think the best thing to do is if you can roll over her video, click the three dots and do pin, then you'll be able to see the slides big on your screen.
And let me know if this doesn't work, and I will share the PowerPoint instead. So if anyone cannot see.
I think it works. Well, let's go with it for now.
Okay.
We all appreciate innovative things, Christina. So you're getting points with us for going this way. So please continue.
Okay. So Greencounsel.se's mission is to automate and connect. Automate so that people do not need to do what the system does better, and connect online so that people can interact in the most efficient way to solve a common challenge. In doing so, we believe that people will have a better work-life balance and a better work environment. And while doing all work online, we can also try to minimize the environmental impact of, for example, traveling to different places and locations, printing documents, etc. So then, why legal tech? 5 years ago, I took the step to set up my own company to focus on legal tech and the development of services to automate in various ways. Particularly in the field of law, it is important to do so, since, as you know, lawyers still charge an hourly fee, and increased efficiency with lawyers' time may lead to lower costs of dealing with different legal cases, and then these legal services will be available for more people. But it's not just about pushing down the time spent by lawyers in a case, it's also about reviewing in different ways how matters are handled from start to end, where there are actions that people are taking today, as the system could just do as well. What measures need to be taken and how are they taken in the most appropriate way? How can technology make it easier to do things in a much smarter way than if we handle everything manually? We have an opportunity to really get a huge leverage from digitalization, but then we must realize that how we used to do things manually, when we did not have the opportunities that technology brings, we settled to do things in a certain way that works manually. So now we have to rethink, when all these opportunities are available, how can we do things smarter? So it's not just about doing things the same way, but in a digital way, but actually see how can we leverage the digitalization. So when we started Greencounsel, we thought that we were thinking about how could we actually try to make legal matters efficient online. We considered what the various building blocks are in a legal matter. It may be to retrieve information, to generate documents based on such information, to have checkpoints where someone has to accept submitted information or generated documents, to sign documents online, have online meetings, to enable people to meet and discuss at different stages of the process. And if you combine such building blocks and also has a structure that determines when and if the different blocks are to be activated, then it's in principle possible to build up any case with a pre-configured path, provided that it is possible to predict what needs to be done at each step of the way. So we built an online system to configure such workflows and matter types, and then enabling them to be run over and over again. And currently, we're also developing a lot of machine learning capabilities in the system as well. For example, we have incorporated a neural machine translation model to handle translations in the system, text analytics, and a multilingual chatbot that can understand questions in different languages and provide relevant answers. The platform itself, we have it in Swedish and English, but it can be extended with more languages if needed. We called the platform David, that means the beloved one, and that was very intentional, since technology is actually not a threat. but it is our best friend when it comes to make legal services even better and accessible. So we should welcome the technology, and I know that I'm preaching to the choir here, but we have a way to go within the legal field to accept the use of technology, I think. We have made available a lot of different workflows for different types of matters, ranging from family law issues to commercial agreements. Complex workflows such as an M&A transaction workflow, starting with the NDAs and ending with the transfer of shares and registrations. And we also have simple workflows such as the generation and signing online of a simple NDA, for example. And here also there is the dispute resolution services that we collect under the name Happy Resolution. And that is what I will now spend the rest of the time of the presentation on. Sometimes it's not easy to simply arrange different modules successively in order to achieve the objectives of a case. In those cases, we have built specific modules that solve a certain type of quite complex handling. One such example is our settlement calculator and our arbitration platform, and these form then part of Greencounsel's Happy Resolution services. I just want to say a few words on the settlement calculator before going into the arbitration platform, because it's really interesting from the access of justice standpoint. It shows what the problem is with today's way of solving disputes on the merits manually. It costs far too much. The settlement calculator is free to use. It's available online at Happy Resolution, and if you use it, you can be assured that we will not retain any data, and it's just for your benefit to check the settlement possibilities in a specific case. The settlement calculator helps to calculate whether it would be worthwhile pursuing a dispute or whether it would be preferable to settle the dispute instead, based on the assessed likelihood of winning different claims presented and assessed costs of resolving the dispute. When you test different disputes in the settlement calculator, it is clear that most disputes where the amount in disputes is relatively low, perhaps 100,000 euros, 200,000 euros, and in that range, those disputes will never be solved on the merits because of the risk of losing, and that the cost for trying to resolve it on the merits is so high. Especially from at least a Swedish perspective, where a losing party is regularly charged both his or her own and the winning party's cost for the dispute. Once there is a dispute over a contract, it is rarely so that a party can enforce the contract legally. As a corporate lawyer, you will see this play out all the time. You always give your internal clients the advice to settle. The risks and disadvantages with an arbitration are too high. Instead, the disputes are generally solved based on other considerations than the agreements and the rights and obligations that you believed would play a more important role. So in those situations, I think the question arises as to the value of having lawyers draw up and review contracts at the outset. If it's not practicable to have them tried because of the costs and risks of a qualified legal assessment, that the costs are so high when there is a dispute. So why should lawyers be even involved in drafting the contract then? So I think the challenge for legal professionals is to find ways to facilitate the judicial resolution of disputes, so to increase efficiency and reduce costs. In that case, the calculation for the resolution of a dispute will be different, and there will be greater access to justice. And an important part of the solution is the information technology and the leverage that it could bring. And also that we review how we work and deal with disputes to take the full advantage of the opportunities offered by IT and the ability to interact and share information online. And this is why we built the platform as well, and I will demonstrate that later in the presentation. It's really interesting, I think, that we have not really changed so much in our underlying working methods. We write, read, and analyze submissions to try to understand what the dispute is about, what is being claimed, what needs to be addressed. A lot of work is being done to try to get an overview of all the different issues and what is being argued in different parts in just the text in the submissions. When everything is handled manually, there is not much more to do than to deal with the disputes as we usually do today, to sit in our chambers and formulate a document which is, as convincingly as possible, explains why we are right and then deliver it so that the other lawyers on the other side can examine it and then respond to it in the same way. The dispute grows and grows with the submissions, and it gets more and more difficult to obtain an overview of what is actually being claimed in different parts. The arbitration tribunal has a particular challenge in ensuring that it does not adjudicate more than has been invoked, and they must ensure that the parties are properly understood. And this often results in a lot of time being spent by many lawyers from different sides to understand the actual tree structure of the dispute and to ensure that everyone has the same view. And the structure itself is rarely clarified until far into the dispute, when the tribunal may take the initiative to carry out an overview of the case in preparation for the final hearings. And then this will, in its turn, trigger further correspondence. Technology and the ability to interact online, that opens up considerably more possibilities to clarify and structure a dispute in other ways, and to focus on what is relevant, to understand precisely what the parties claim and how that relates to what the opposing party claims. And we try to build on that and consider how a data model for a dispute could really look like. At the top, there are a number of claims which can be made by different parties. Beneath, there may be a number of reasons why they consider that they are entitled to those claims. Beneath such legal grounds, there are a number of facts to support the applicability of these legal grounds, and finally, evidence to demonstrate that the facts invoked are correct. A fact may support different legal grounds at the same time, and the same legal ground may support several claims at the same time. For each claim, legal ground, facts or circumstances and evidence, the other party should also state his or her position, and where appropriate, indicate the basis on which that position is supported by new grounds, facts and evidence. On the basis of such data model, the parties may then gradually start building the dispute together online, so that if one party sets out its claim, grounds and facts, the other party can respond. And that may give a reason for the first party to adjust or add to what has been said. And it's incrementally, you're setting out the actual structure of the case in an overview. All take place in an online digital dispute overview that allows you to submit different data, give access to your client for any comments, and then choose when to submit. So what you have inserted into the overview is also available to the other party and the arbitral tribunal. The tribunal can monitor what has been submitted by the parties at different points in time, what is the current information, and if necessary, they can also ask questions on the platform in case of doubt. The tribunal can enter the system and make draft assessments of the various issues until they choose to disclose it to the parties, as for example, a partial award. The tribunal can also book final hearing online in the system, and any witnesses will also be called at the time set. Since the dispute consists of this structured data, you can also use the different sets of documentation to be generated. So you don't need to write that manually. You can use the structured data to compose, for example, a draft arbitration award, which the arbitral tribunal then can verify before signing of the finished document online and making it available to the parties. So 2 years ago, we tried to build this platform to make real these assumptions about how to handle a dispute with focus on the structured data of a dispute. So we built a specific module on our LegalTech platform to deal precisely with the work that parties and tribunals need to do to clarify what is being claimed in a dispute and how to assess what is being claimed. So this is the backbone of the happy resolution arbitration service. The arbitration service is structured as a workflow where a claimant first enters some basic facts online about the parties to the dispute, and then the module of the arbitration platform is launched so that the claimant can also enter its claims and legal grounds so that the platform can generate a draft request for arbitration. The parties then book a 45-minute online meeting where they review together with the happy resolution the various options available to resolve the dispute, where arbitration is just one way to go forward. You can also choose, if that suits the parties better, mediation, or for example, trying to find a settlement between the parties on their own. But if they choose to proceed with arbitration on the platform, the parties may then enter into an arbitration agreement or agree to use the platform to deal with the dispute under the rules of another arbitration institute. The parties may also deal with the selection of arbitrators online, where the arbitrators are consulted and can declare any potential conflicts of interest and availability online before they can be confirmed by the parties. In the meantime, the parties can continue to include information on the dispute overview and build the dispute and what is claimed in the dispute at the same time. And once appointed, the arbitrators are given access to the platform as well, and they can get an overview before planning the final hearing, and they can ask supplementary questions, if any. So now I think that I've spoken sufficiently, and I will go over to a demo. But just first, I really appreciate to be able to get in contact with all of you who are so much into online dispute resolution. So if you have any feedback today, or if you have come to think about anything afterwards, you are absolutely welcome to contact me at info@greencounsel.se. If you have any questions or any feedback on what you have seen here today. And Happy Resolution is also available at www.happyresolution.eu, and there you can click around and see some further videos and recorded demos of the different services. And well, just click around and read about it there.
Great.
So now,
Christina, you're part of the family now, so you're going to get a lot of feedback from a lot of us.
I'm really looking forward to it, because so far I've not gotten that much feedback from the legal community. So I'm really longing to hear other people's views and challenges, and if you see something that could be improved, and I'm sure there is a lot of it. So sure. Just bring it on. Let me see now if I will try to share my...
start up the demo. I just wanted to ask, we would like to list you on ODR.info, which is our provider list of ODR platforms at the National Center for Technology and Dispute Resolution. Would you prefer to list Greencounsel.se, or would you prefer to list happyresolution.eu?
I think it goes both the way around. I guess Green Counsel is the company's name.
Okay.
But the dispute resolution services, I collected that under Happy Resolution. But the company name is Green Counsel.
Okay, great.
Let me see. Can you see my screen now?
We can. Yeah, we can see it. Looks great.
I will just see so that I'm still logged in. It's a little bit slow now, I think, because I'm sharing so much broadband in the video, but I think it will work. So just showing here how you start the service, because you do it completely online. And let me see if I can just take it to English as well. So just enter the parties' names. I just show a bit how it works, and you submit some information that is requested, and you submit that information, and then the workflow has started, and you're on the way to have your dispute solved in Happy Resolution. But I think I will focus the time here to show the actual arbitration platform where parties submit information and show how we have set this up with the structured data. So you do not submit any documents in the dispute. Well, of course, if you have evidentiary documents that you want to submit, then of course those you can upload, but you do not submit any briefs or submissions. You just enter the actual data on this dispute overview. So everyone in the dispute has access to this overview. Here is a case between Fiskmåsen and Mullvaden, just not a real case, of course. You choose the party. Now I'm only authorized to work with Fiskmåsen Fire AB. I'm registered as a counsel of that party, so I can only see the draft. Here I'm showing the draft right now. I can only see the draft for Fiskmåsen, so I cannot see what the other parties are doing that is not submitted, of course. But here I'm now in a draft where I can change, make amendments in what is stated. So for example, if I want to, let's say that I want to change the actual request here, and I will instead say 5 million SEK, and I update it. And then that is automatically updated in the system. And you can see that it deviates from the submitted version. So that's not something that I need to submit in order for it to be visible to the other parties in the tribunal. And there are other items here that is already submitted. So there has been no change there. For the request here, it's supported by 2 legal grounds. So if I click on one of them, it goes to that legal ground, and it's invoked as a legal ground to both of the requests made in the dispute. And it's supported by a fact that is also entered here. And that fact in itself has evidence supporting that one. So you can just click around in this dispute overview to see what has been alleged in different aspects. And you can see that the opposing party, if I had been logged in as an opposing party, that party could then change how they respond on each row to what I'm claiming. So for example, if I have said here that the claimant understood that the deliveries were important, then the other party has stated that they did not know that the deliveries was important. So you can contradict each other then immediately where you have inserted a fact or a circumstance or a claim, etc. So it's a question about moving through each row and see what does the parties allege in this aspect and what has the other party responded. And then each party can then have, for example, here the other party has invoked 2 circumstances in support of what they claim here. So in that way, the actual tree structure is built up. So everything is connected the way it should be, and you can see what is actually claimed for each request ground and circumstances, etc. So now I'm showing a draft, and I have made a few amendments previously, and if I then want to submit them, then the platform shows me what is the changes that I have made compared to what I have submitted previously. So then it tells me, okay, here it's 5 million SEK instead of 2. So that will be updated if I submit that one, and I can uncheck it if I do not want to submit that yet. So I don't need to submit everything at once. And here I have added that a certain legal ground should be invoked in support of one of the requests as well, which I'm not invoked before. So as soon as I submit checked information, that will be submitted and will be available to the other party and the tribunal. And I can also, the system also keeps track what has happened in the dispute. So you can make comparison between what was alleged at different points in time. For example, if I compare to what I stated, for example, here earlier today, compared to the draft now, I can compare those versions. And you can see there have been some changes. So I can see what has changed as compared to what between different points in time. That is also a functionality that can be good when the other party has submitted something, that you can immediately check what is different, what changes have they made. And then I can also show the published version, what is what is actually what is submitted by both parties at this point in time. There is also, as I said before, there are possibilities to generate with this structured data. You can generate a lot of documentation that you would otherwise need to write manually. Actually, perhaps in the future, if we start to work with disputes this way, we will perhaps not need any documentation, but still, I think we still require some sort of documentation for the dispute, statement of evidence, or of course the arbitral award and similar. But in the future, actually, do you really need the documents? Would it not just be sufficient to have this dispute resolved here online? Because here, actually, some of the claims here were already resolved by the arbitral tribunal. The tribunal had already made a decision on certain rows here, and that should perhaps be sufficient. So that's just a way perhaps for the future. But for now, it's possible, for example, for a party to make a statement of their own claim. So you can see what has a party actually alleged in the dispute at this point in time. Now, unfortunately, I would need to, I can perhaps just change what I'm sharing because it opened up in a separate window, just so that you get an idea how it could look. Let's see if I can just change for, perhaps I can just show my screen for now, and that would be easier. So like this, for example, that it tries to it uses structured data and go through and specify everything in a written manner. Of course, since it's generated, it's not that beautiful text because it's very automated, but it says what it should say. And there is also a possibility to change that also afterwards manually if you want to in any aspect. You can also get a dispute overview, a printout of what, essentially it's very similar to what is in the actual dispute overview here online, but let me see if I can get it up. But you can have that also if you want to in a Word document where everything is stated in the same manner. So it just retrieves the data and builds it up in the same manner. Yeah, I think you get the point. So there is a lot of opportunities with building the case through structured data and to get them a lot of manual work done by automating the underlying documents. And you can even, the arbitral tribunal can even generate the arbitral award based on what they have submitted. So it can describe what has happened during the dispute and what the parties have claimed and alleged, and then also how the tribunal assesses the different aspects. There is also possibility to make online meeting reservations, prepare hearings and the agenda for the hearings, and well, here's a simple way. Everyone involved here now, it's just me in different roles here for this arbitration, but there you can set an agenda and a title, and it will schedule a meeting online with the online meeting platform that you have available. I'm using GoToMeeting myself, but Zoom will also, of course, work if you can enter that in your profile, which link to use, so that everyone get access to that one in the meeting invitations. Let me see something else that I can actually go to the draft again and just so depending then on what role you have when you're online, you will essentially have access to the same process overview, but depending on your role, you will see different opportunities to put in information. Arbitral tribunal will be able to give procedural orders and request that further that party answer something in relation to one of these rows. And they can also make assessment of each of the rows, whether it's granted or not, so to speak. And then when you are ready to submit something, I'll just end the demo here. To submit these changes, you just check this, and then you will see it changed to 5 million SEK as I required, and then yeah, everything is up to date. So I think I will stop here, and if you have any questions or spontaneous reaction, it would be really interesting. I would be very interesting to hear your views on whether you think that this is a viable way to solve disputes online, because I also want to be transparent with you that I have not so far seen that much interest in solving the disputes. It may be that my marketing is not that successful, but I've not so far seen any, not even from lawyers' side, to evaluate whether this could be a way to recommend their clients to solve disputes in a more efficient manner.
Well, let me just initially say, I think this is very cool, very impressive. It's a lot of work to pull this together. And I think the document generation is amazing. You know, once you can get an arbitration into structured data, you can do a zillion things with it. And I think that's very exciting. But Merez has her hand up. Merez, what did you want to say?
Yes, thank you, Christina. This is really amazing. So first, to answer actually your question before asking you questions, I don't think it's a question of marketing, although I had a question about this also. I think that Colin and all the friends connected can confirm that actually, unfortunately, people continue to think that online dispute resolution is science fiction, although there has been some progress recently, and I was very happy, and I told Colin, I was very happy that last week at the Paris Arbitration Week, which I attended, we were, by the way, 500 people kissing and hugging, and nobody cared about any virus or whatever. We were so happy to meet again after 2 years. I was very happy, and I told Colin that actually this is really a victory to see that the arbitration community has invited online dispute resolution practitioners to join a panel and speak about online dispute resolution. And I think that the conference was great. It was interesting to show people that there isn't only arbitration, but there are also consumer disputes, small disputes, and other types of disputes which may be resolved online. So the problem is really the mindset of people that needs to be changed. We need still, until now, for over 2 decades, Colin has been around for over 2 decades, actually for almost 3 decades. We've been around for over 2 decades, and we must still, unfortunately, fight to have people understand that it's something which is viable, and it's not the future, it's now, and we're already lagging behind. So it's a question really of education. I don't think that it's a question limited to marketing, but we will hear from other friends connected their opinion. Now, my questions to you, Christina, you know that when we discussed about this, and now I've seen it more in detail, and I think it's really amazing, because so far I haven't seen a platform suggesting exactly what you're doing, actually preparing the entire work for the parties, who can also do away with lawyers. They can do it themselves, because it's so well structured that they can take their case online themselves. So it's a spare of time and money also. So I think it's a really very interesting platform, and I really hope that there will be people interested in it. So first, my question is to know if an organization or a firm is interested in purchasing this not the platform, but the license. How does it work? And are you going to assist them in implementing the system on their system? And will you be assisting them also throughout in order to update, in order to fix bugs? I mean, how does it work really? Or is it that you host on your platform whoever needs to be using this platform, any organization or firm. So this is the first question. Can I put through also two other questions? I believe that what you mean by deviate is amended. So an amended request when you as a council modify something in your request from 2 to 5 million, for instance. So my question here is whether you can decide to show the modification you have made or whether to hide it. I believe you need to show it, because if I was the opposing party and I saw that you initially claimed 2 and now you claimed 5, I need to see that reflected. So is it something that you need to decide whether to show it or not, or does the system show it in any way?
Yeah. For the first question, the Greencounsel is a startup, and that means that we try to, if there is a need, if there is someone who wants to do it in a certain way, to set it up under their own white label or something, that is something that we will certainly look into if that would be interesting for someone. But for now, currently, we offer this system on our own platform, and it's available for any commercial party. It's not available for private persons, but it's available for commercial parties to use if they prefer. And as I see it, it could be an ad hoc arbitration that they use it in, and it could also be used in an institutional arbitration, which is subject to an arbitration institute's rules. But then, of course, you need to see to that those rules are adhered to as well. But for now, it is set up in that way. The cost for using the system now is approximately 900 euros per party and dispute. So you get access to the platform for the actual dispute that the parties are involved in, and for a one-time cost for that dispute. There is support is in addition to that, but of course, if there are any bugs or anything like that, we will ensure that the system works and fix any issues that are on the system side. Mm-hmm. But I should also say to this, and I'm sometimes I'm a bit too honest, I think, to have a startup. That Greencounsel is a company without external funding, and we do not have a great team, a large team behind us. But I think that I work quite efficiently myself as well. So it also all depends whether there is an interest in the market to use this, and I'm sure that it will that it will work fine. As for your second question, amended requests, and to show what modifications are made. For now, it's not automated so that when a party has submitted something, that you instantly sees a comparison that you need to do yourself, go into that when changing, which I showed, make a comparison yourself when you see that something has changed or been submitted from the other party. But that is naturally something that could be considered as well, to have perhaps a button where that is automated as well, see the changes as compared to the latest submission, perhaps, so that you don't need to go and trigger that with several clicks, that you can do it just with one click. So I will just take a note of that so I can remember that good idea.
Yeah, but I think it makes sense, because if I'm a party again and I saw at the beginning 2 and then I see suddenly 5, I need to understand why. So it does make sense. And coming back very quickly, if I may, Colin, to the first issue with respect to the marketing, mm-hmm. You know that when we spoke also, I suggested that perhaps you can reach out to EU that alleges to have an ODR platform, which is not an ODR platform. It's simply a platform providing information about ADR, not ODR, providers. So I think they really need a system, and that can be a very good system. Now, that being said, for small disputes, consumer disputes, it may be expensive, but at the same time, it may depend on whatever may be agreed with EU. And perhaps in the future, when you will have many clients asking to use your services, then the team may expand. But I hope that this will be used because it's really cool. One last question is about evidence. You mentioned that probably we don't need to upload documents, but how is the arbitrator going to base or arbitrators going to base their decision on the claims?
In relation to evidence?
Yes.
Yeah, because there of course, if there is documentary evidence, that of course can be uploaded. So you can submit, you can enter written evidence, and then you need to submit what that written evidence actually is. So in that case, you absolutely need to upload the evidence and the document. But for submissions and briefs, etc., that you do not work in that way, and you use the structured data instead.
Okay, great. Thank you very much, Christina. This is absolutely great. Thank you.
Thank you.
Yeah, I couldn't agree more. Let me ask you a couple other questions, Christina. First of all, in terms of marketing your platform, that's what you're doing right now. So this is a key group of thought leaders in global ODR, and for us to be aware of your platform, that's a big step forward. I put a link to your platform on the odr.info panelist, and we would love to have you in Dublin. We'd love to have you at these meetings so you can continue to show it off and continue to refine the system. I will say I've built several arbitration platforms over the years. I remember when we first started Modria, we designed an online arbitration platform for documents only arbitration with the CPR Institute for dispute resolution. And it's very complicated. It's complicated to build a system that can track changes as your system is done, and organize all of the various issues, claims and counterclaims in an arbitration in an intelligible way, and also generate documentation. Clear documentation about what is the offer from one side, what is the proposal from the other side, what is the decision on each item. I think you've done an incredible job, and I think this is a very, very. I mean, I'm not an arbitration expert compared to many of the people on this call, but for me to go in and look at your interface, and in about 5 minutes, I go, I completely get this. This completely makes sense to me. I think the structure of it really works very, very well for an arbitration. I will say, Hurt asked the question in the chat. As a mediator, he's wondering if the software can be also converted into more of a mediation project management tool. It seems to me this is very kind of arbitration. It seems like this is the way the lawyers think about the way cases are handled. Do you have a design of this that's also designed for mediation?
If to the extent that mediation, if it can be facilitated in knowing what your legal position is entering into mediation, this could perhaps it should not be resolved by an arbitral tribunal.
Sure.
But at least the parties can try to figure out what is it actually that we are disputing about, and then perhaps they can resolve it. Mm-hmm. Otherwise, such a granular way of looking at a dispute, I think that is made for arbitration mainly. But I'm definitely interested to discuss further how you can facilitate mediation even more. For now, we have a simple mediation service on the platform as well, but that is mainly about booking up a meeting with a mediator and go from there. So it's not that much technology behind it than that, just to have the mediator meet the parties.
Well, I do want to open it up to see if others have feedback. I will say, I think you said it's 900 euros per party to use this platform. And I will say, just my experience of selling into ODR, that's high. That's an expensive price. Now I know we're talking about arbitrations, and you may be targeting high dollar value arbitrations. So that may be, that's a rounding error if we're talking about $100 million case. But that may be hard to get traction at that initial price. Again, if you wrap it with services, if you find a way to say, well, hey, I'm going to work with the Stockholm Arbitration Council, or I'm going to work with the ICC, or I'll work with, the LCIA, and then you're providing an arbitrator plus case management plus this platform, well, then those numbers make sense. But I'd be curious to hear what other people think as well. The other thing that's good about software like this is putting it in the hands of as many people as possible. So, you know, as Bob just did, I don't know if you've seen his next level mediation platform, but in going through that, and he also has a very powerful, sophisticated platform that uses decision science. He's designed a training that walks people through it and explains all the functionality. I would also urge you to do something like that. Think about what would be a short training course. A demo like this is very helpful, but to walk through and then maybe certify a provider so that they're kind of a, you know, an expert in using your system, and then they can go out and then they can be sort of a marketing and sales team for you as well. So that's just a couple of my thoughts, but I want to open it up to everybody else on the call too. Yeah, Bob, what did you want to say?
Yeah, well, thanks for the presentations, Christina. I can say from personal experience in startups that getting it off the ground is slow. It's not necessarily the marketing. It's in the case of legal markets, its adoption is slow. And it just takes a lot of patience. I would, as Colin said, I would look at the pricing model that you have for adoption, because you know you want to get the early adopters, and they tend to not spend as much money because it's new technology, and then later on you can change the pricing models. But you know, part of my background is business simulation, as I used to run Intel's decision analytics group, and so I have a simulation of this kind of software. If you want to use it, I'll just give you a link. You can use it, have fun with it, try different models for market diffusion. And
that sounds very interesting.
Yeah.
I'd encourage you to explore also integration. I think, you know, I'd be interested to see kind of your underlying case management functionality and sort of your intake and neutral selection, but I don't know if you have an API. What was the platform built in? Do you mind me asking?
Well, the platform, I mean, it's possible to integrate it. It's built on partly Python, PHP, and so. Excellent.
Yeah, well, I think plugging it in with other existing systems is a good way to get more attention. And I think your tool does one thing really, really well, but it may be that plugging in with other platforms that do other things like case management and neutral assignments, you know, they may have more caseloads that they could drive to your platform. So that's another way to think about opening multiple doors to getting cases to use it. But the other thing I'd urge you to do is writing articles about this and presenting at conferences. I mean, we would love to run an article about this at mediate.com. I see Claire just put up her, a thumbs up. At arbitrate.com, I think people will be very interested in this. So, you know, the more hands you can put it in, the better, because then people will become more aware of it. But yeah, just optimizing around user experience, I think, is key. So we're getting to the end here. Any other comments, thoughts, reactions? Anyone else want to say, offer some advice? Please, Tim, I was thinking about you watching this demo.
Thank you, and thank you for a great presentation. I've been fascinated. My spontaneous response is I think the thinking is great, and I think it's so different to the way that lawyers do their work now that I can see your theme of efficiency and cutting costs. So I'm very attracted to it and congratulate you on the thinking from my inexperienced perspective. In terms of lawyer reaction, don't be surprised. That's how lawyers are. And it takes work and perseverance and determination. I say that as a mediator who's been trudging through the foothills for years. I will contact you. I think there are a couple of bodies in England who may be interested in the thinking. We have a Civil Justice Council which looks at civil justice policy, and they have a Futures Working Party, and I think they may be interested. I'll give you their details. We also have coming into being fairly soon an online rules committee. Because presently, when we want to do anything to do with tech, we have to write rules in the old-fashioned legal way, and then those old-fashioned legal rules go off to the software people as business requirements, and they try and make sense of them. And there are whole piles of things in those rules which are not necessary when you have tech. But we have realised that now, and I think the ODR community should be very pleased that there is an online rules committee which is going to look at developing online rules and building the rules into the software. And I think they may be very interested in your thinking. So I'll be very happy to put you in touch.
Sounds very interesting. So please email me. Yeah.
Great. And so I guess I just want to say thank you so much, Christina, for joining us today. This was a fascinating presentation. I'll edit down the video and I'll have it up on the ICODR website soon for some of the people who weren't able to join us in real time. But if you could join me in giving Christina a round of applause and thanks for spending time with us today.
Thank you.
Wonderful. Christina, I'm sure we're going to be seeing a lot more of you in the coming years as your tool gets more and more traction. But thank you so much, everyone, for joining. Be well. Take care. We're actually not going to do an ICODR meeting next month because it would be happening during the same time as the Dublin conference. So please take the time to join in Dublin, and we'll see you in either online or in Ireland. And then we'll resume our cadence of these meetings at the beginning of June. So take care. Thank you, and we'll see you soon.
Thank
Thank
you.
you.